Are you Ariana Evans?
Yes, ma'am.
And this is 22-41163, and Miss Evans is currently on probation for a lesser offense of terroristic threat against a public servant, a Class A misdemeanor, and previously in court entered pleas of true to counts 2, 3, 4, and 5. I received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor. Yes, Your Honor, I have.
Right away, you can feel this isn't a fresh case. This is someone who already got a second chance. A felony reduced to a misdemeanor is huge mercy in the system. That's the kind of break people pray for. And the court is reminding everyone of that before anything else happens.
Yes, ma'am.
GPS device, I was just emailed by Friday, 5:43, that it's been dead, the battery's been dead for 3 days.
Okay.
It's not being tracked at this point.
This part might sound small, but it's not. A dead GPS for 3 days isn't an accident. It's silence. And in probation, silence is loud. That's trust being broken, whether intentional or not.
Provide an option that if the court does consider maintaining her own probation.
Well, she doesn't want that.
Sir?
She doesn't want that, right?
What do you want?
I mean, it says right here, she just wants to do her time so she can move on with her life and put the case behind her.
Is that accurate?
Yeah, but I mean, if I like get the chance to like get reinstated, I'll do it too.
Which details, Harris? What do you want?
If I can do the 60 days that they offer me and be off.
This is where things really start to slip. When someone says they'd rather sit in jail than follow probation rules, the court hears something very specific: resistance. Probation only works if the person actually wants structure. Without that buy-in, the system stops bending.
For her to address this situation is to take the revocation and take jail time on it. However, the defendant's version does indicate some mental health issues. And obviously, probation is a system designed to try to keep people out of the actual criminal justice system in the future and avoid incarceration. So just looking at this, since it is just a misdemeanor, I would suggest, just in her interest, and perhaps in the interest of the community, that she be continued, follow the maybe the recommendation you adjudicate with 30 days up front, or no upfront time, but the mental health component be addressed with Ms. Evans to see if she can make progress with her so-called incorrigible attitude, which I think under the DSM may be diagnosed as an antisocial personality disorder, whatever her issues are from the mental health standpoint.
Did you see that somewhere, or did you just make that up?
Well, I think that if they're saying she's incorrigible, I mean, obviously I'm not a mental health expert.
Okay, I just didn't know, I didn't see anything where she was diagnosed.
She hasn't been diagnosed with that.
Okay.
There's probably some issues there with.
This moment is uncomfortable to watch because mental health is serious, but it has to be handled carefully. When it's raised without records or diagnoses, it doesn't help the defendant. It actually hurts credibility. You can hear the judge pulling back right here.
Judge, I think incorrigible and defiant means she doesn't want to do probation, doesn't like people telling her what she can and can't do. I'd ask that we revoke her.
And just like that, the tone changes. The state isn't negotiating anymore. Once both sides agree she doesn't want probation, jail becomes the only tool left on the table.
Ms. Evans, I mean, you were given, number one, you were given a great opportunity because you had a felony and they reduced it to a misdemeanor and put you on probation for 2 years. It looks like they gave you all types of help through JCDI, and you failed to complete your groups, didn't obtain a sponsor, you were testing positive, you were ordered to the Franklin North so that you could get some more intense help. You did okay in that, and then you got out and started struggling again. You were also ordered to go to Spindletop for mental health treatment so that you could get the help that Mr. Kimler is saying that you might need. And looks like they say you attempted to circumvent the requirements to obtain a sponsor. Your sister pretended to be your sponsor. You were placed on zero tolerance in JCDI. You tested positive for alcohol. You left the state without permission. I mean,
This is the judge laying everything out. Not emotionally, but methodically. Every program, every opportunity, every warning. This isn't anger, it's exhaustion. The court didn't fail her here. The system kept trying, and at some point, Accountability replaces patience.
All right, I'm going to find that you entered your pleas of true to counts 2, 3, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor of terroristic threat against a public servant. I'm going to sentence you to a term of 180 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you were previously in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was not an agreement. You do have some rights to appeal. Y'all need to sign that real quick, please, Mr. Kimler, and give her that bottom copy. And he'll give you that copy of that, and then you can go with the bailiff.
The sentence lands, and that reaction, the snort, the dismissiveness, says more than words could. In court, reactions matter. They linger. And when you look at the full picture, this wasn't just about one violation. It was about refusing every lifeline offered,